Hello, everybody.
Kansas versus Destiny Rose Bookout. It's case number 2024 CR 517. James Watts again appears by Zoom, as does Brett Sweeney from the Butler County Attorney's Office. Destiny Bookout now apparently has been taken into custody, and he appears from a judicial center, a Zoom location. This matter comes before the court at this time for sentencing. Ms. Bookout, this was scheduled for 10 o'clock this morning, but you were not here. We even waited for you to give you an opportunity to get here late, and you didn't show up. Is there an explanation for this?
Your Honor, I was on my way here. I got stuck on the highway because there was a traffic jam. I got here about like 15 minutes after 10.
Well, that's 15 minutes too late as far as the court's concerned. We waited. You didn't show up until after the court proceeding was over, and the court had already ordered bond forfeiture, bench warrant, and a no bond hold. So I trust you've been held at the judicial centers in detention waiting for this hearing, correct?
Yes, Your Honor.
You're darn lucky, Ms. Bookout, that the court worked you in at this point. We're going to proceed further with your sentencing proceeding at this time. Again, noting for the record that the defendant had been convicted back on February the 18th of possession of methamphetamine, a level 5 drug felony. A pre-sentence report has been received. Is there any objection to the criminal history as stated in this report, Mr. Sweeney?
No, Your Honor.
By the defense, Mr. Watts?
Excuse me, Your Honor, I have reviewed the scoring with my client. We believe it is correct. We have no objection.
Court will adopt the criminal history stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed further accordingly. Mr. Watts, do you know of any legal reason why sentence should not be pronounced in the Bookout case at this time?
No, sir.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Ms. Bookout, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other type of sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Are there any victims or members of a victim's family present who desires to address the court in relation to the Bookout sentencing? Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Bookout, starting with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, the state is recommending 15 months in the Department of Corrections. Ms. Bookout is eligible for the 20% maximum good time percentage. As well, she would have a 12-month post-release supervision duration. She does have 44 days of jail time credit. She's currently on community corrections in Sedgwick County 22 CR 1496. There's a special rule that's listed on the face sheet of the PSI, and the state would ask the court to run this case consecutive to that 22 CR Sedgwick County case. She is a mandatory Senate bill in this case, at least, even though I don't think that she finished all the Senate Bill 123 pre-sentencing evaluations. I think it's she does qualify. I think it's appropriate to go ahead and sentence her, obviously. The state would ask that the up to 18 months of community corrections probation be adopted. All of the standard conditions that include compliance with the Senate Bill 123 treatment. It sounds like she is doing some of that in Sedgwick County. Although in speaking with Ms. Ashenfelter, it sounds like she's flunked out of inpatient treatment, which is where she was. And I mean, this is the information that I've been given. And that maybe that's resulted in a warrant as it relates to the Sedgwick County case. So it's kind of in an interesting position that Ms. Bookout finds herself in, where she's mandatory Senate bill, but she's already kind of on a similar path in another case, but not doing so well. I'll just leave that at that. As far as costs and fees associated with the case go, Your Honor, the state's not requesting a fine. We are requesting the court costs in the matter. There was a KBI lab report, so the state is seeking $400 in restitution. We're seeking $300 payable towards the Senate Bill 123 treatment, correction and supervision fees, and of course, attorneys and bids fees if the court finds those appropriate.
Thank you, Mr. Sweeney. Mr. Watts, your recommendations regarding an appropriate sentence?
Your Honor, this is a Senate Bill 123 case. The recommendations of the state are normal and expected for a Senate bill case. The one thing I will note is, as Mr. Sweeney put it, if she is struggling with her Senate Bill 123 issues over in Sedgwick County, she'll have an opportunity to get those issues straight in this case. But I would guess I would put on the record, and for Ms. Bookout's benefit more than anyone else's, this is now a second drug felony. A third drug felony would result in a presumptive prison category. That's something Ms. Bookout ought to be well aware of as she goes forward. Judge, as far as the sentencing recommendations, I think mine are in line with the state's recommendations. Thank you.
All right. At this time, the court will address the defendant, Destiny Rose Bookout, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court.
In regards to Mr. Sweeney saying that I flunked out of treatment, I was actually medically discharged, and I have a bed date for another inpatient treatment facility scheduled for tomorrow.
Oh, what facility is that?
Cherry Creek.
Okay. All right. Anything else? Ms. Bookout?
No, Your Honor.
The court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of G, thus placing her in grid box 5, drug G. Court hereby sentences the defendant to a term of 15 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed. Court does note that this would generally be a presumptive probation case. However, I do note the application of a special rule here. This crime was committed while she was on community corrections for another offense. The court will run this case consecutively to Sedgwick County case 2022 CR 1496. And even if the law didn't require it, this court would do it as a matter of discretion in this case. So court will run the case consecutively to the Sedgwick County matter. Court does note that in this case, the defendant had a high risk score on the WRNA, and that her SASE indicated that there's a high probability of a substance abuse disorder. This makes this a mandatory case for Senate Bill 123. Court does order the defendant to complete a drug treatment program and aftercare requirements for a period of up to 18 months. That will be the length of her community corrections probation granted by this court, up to 18 months. Conditions being that she report to an ISO as directed, observe all laws, obtain an approved substance abuse evaluation from her community corrections officer, and abide by the recommendations of that evaluation. Ms. Bookout, I understand your plans to enter into a new program, but community corrections has to approve your entry into any new program. So before you enter,
Okay.
you need to make sure you get specific permission and consent from your community corrections officer. You shall not possess or consume alcohol or illegal drugs. At your ISO's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment suitably throughout your probationary term, notify your supervising officer of any changes in employment, residence, telephone number, or email address within 24 hours of any such change taking place, have no contact with any co-defendant, abide by any curfew or travel restrictions associated with community corrections programming, and to be assessed and considered for Senate Bill 123 by Community Corrections and follow the recommendations of the new substance abuse evaluation or the approved substance abuse evaluation. The court will also authorize Community Corrections to require the defendant to reside in a long-term sober living environment. Court will be assessing a felony docket fee, felony probation fee, community corrections fee, $300 reimbursement to Senate Bill 123 programming, and a $400 restitution amount to the KBI laboratory. Given this defendant's treatment needs, the court will be waiving any bids assessments in this case. And Ms. Bookout, this court is empowered to sentence you to up to 60 days in the county jail as a condition of probation in this case. This court wonders if Senate Bill 123 is going to work for you. I wonder if you're really highly motivated to successfully complete a community-based treatment alternative, or if maybe you shouldn't just do your prison time to separate you from illegal street drugs, especially dangerous ones like methamphetamine. Perhaps an additional period of jail time would be necessary to reinforce for you that this is a serious matter and that you need to comply with rules. Is that going to be necessary here, Ms. Bookout?
No, Your Honor.
Court does note that this defendant has served 44 days previous jail time in this case. I hope that's had some impact, Ms. Bookout, as well as the 2.5 hours additional detention that you've received waiting on this hearing. Court will grant the defendant relief from any holds in this case, effective at the end of this court proceeding. However, I'm going to direct law enforcement here at the Judicial Center to check for any warrant holds that this defendant may have from other jurisdictions. Certainly not releasing her from other holds other than this case. As stated earlier, the court does award the defendant 44 days and 2.5 hours of jail time credit. At some point in the future, Ms. Bookout, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have the right to appeal their conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, Ms. Bookout, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Bookout, if you've previously been married to methamphetamine, you need to get a divorce right away, because if you don't, if you continue to deal with dangerous drugs, you will end up in prison. If you'd rather be in the community working on any addiction issues, then you need to choose to do so and not relapse. Very, very important. All right, I do have Christy Ashenfelter from Community Corrections on this meeting at this time. Ms. Ashenfelter, what direction do you give?
Your Honor, if I could please get a breakout room with the defendant after the hearing.
It will necessarily need to be very brief and concise, but I think we can accommodate it. Ms. Ashenfelter. All right, and Ms. Bookout, you need to stay on this Zoom meeting after everybody else gets off and meet with the Community Corrections officer by Zoom and follow that officer's direction about what you need to do next to be successful on your Community Corrections probation, okay?
Okay, Your Honor.
All right, Mr. Watts, anything further at this time?
Only one thing, Judge, and I may have missed it. I thought I heard Your Honor announce 15% good time earlier rather than 20. I may have missed.
Uh,
saying no,
I
so
think
I
the
may have
legal
misheard
amount
it.
would be 20% of good time credit.
I think so as well, Your Honor.
Uh,
I may have misheard it.
if necessary, the record is corrected. It's 20% good time credit.
1996.
Mr. Sweeney, anything further at this time?
No, Your Honor.
All right, Ms. Bookout, you have any questions about what we've done here?
No, Your Honor.
Okay, stay on the meeting and discuss matters further with the community corrections officer. I don't see her on screen anymore.
She's already in the breakout room.
Okay, join the breakout room,
Go ahead and bring it up.
Ms. Bookout. If there's nothing further, the Bookout matter will be in recess at this time. And we'll recess proceedings and stop the record at this point.
Be safe, be well, sleep sweet, and much love.